Good afternoon. Thank you so much for being here. This is Crossroads, which is a project of Interfaith Alliance of Iowa. I'm glad that you have joined us today, whether you are here every month or whether you are new to us today. I'm Connie Ryan. I'm the Executive Director of Interfaith Alliance of Iowa, and we are very glad to be able to have Crossroads. And really, I don't always say this, but thankful to Plymouth Church. I was having a conversation. Yeah. I was having a conversation with somebody a little bit ago, and I need to go back and look because I never remember, but we have done Crossroads, I think 18-ish years, give or take, always at Plymouth. And they have, that's not true, a couple times they kick us out for various reasons, but mostly at Plymouth. And we're just grateful for the partnership, and we consider Plymouth Church and several other churches and congregations, houses of worship, to be partners in this work. But grateful to Plymouth, who has always graciously allowed us to use the space free of charge, might I also say, as a partner organization, which is obviously a huge support to the organization to be able to do this. We also partner with a couple of different houses of worship in Cedar Rapids to do a similar type luncheon there, so grateful for their support as well. So, and just thankful to have you here in the room, and we have a full room today. And for those of you who are online, thank you for being with us as well. We're very glad that we have figured out how to reach more people in this world of streaming and online. So thanks for all of that. I told you last month that we've had some really great speakers this summer, and I consider this to still be summer, right? And packed rooms, and it just says to me how important these issues that we do that are to you, those issues are to you, and how important educating folks on the issue is, and how important having you as part of this work, because Interfaith Alliance of Iowa really at the heart is about you and making sure you have the information and the tools to have conversations in your community, have conversations with friends and family, have conversations with lawmakers. And so grateful that all of you are engaged in this work. On Sunday, does anybody know what Sunday is other than it being Sunday? It's Constitution Day, if you don't know that. And so we invited Mark Kende from Drake Law to talk with us about the challenges facing our Constitution, if we can say it that way, and also the opportunities that we have, challenges to our civil rights. And so we're grateful to Mark for saying yes and for being here. Mark Kende is a professor of law at Drake Law School and director of the Drake Constitutional Law Center and James Madison Chair in Constitutional Law. So he might have a thing or two to say about the Constitution and the challenges. Mark teaches constitutional law, comparative constitutionalism, and civil rights. He has been a visiting professor at the University of Paris and at Notre Dame Law Schools, and a Dean's Visiting Scholar at Georgetown Law School, you know, those little law schools in our nation and world. He also spent a year as a Fulbright Scholar in South Africa. Mark is the author of Constitutional Rights in Two Worlds, South Africa and the United States, and Comparative Constitutional Law in South African Cases and Materials in a Global Context. He has authored articles and a book chapter on abortion, as well as given legislative testimony on the topic. He is an elected fellow of the American Bar Foundation. So will you please help me to welcome Mark Kende.
Good afternoon. Can you all hear me okay? Great. Well, it's just an honor to be here. Technically, I have to say that it is Constitution Day, as Connie mentioned, on Sunday. So if you have a pocket constitution or you have an opportunity, you know, it really is interesting to actually read the document. It may not be the easiest read, but you know, take some time on Sunday if you feel like it, and take a look at the document. It's really something. So the topic online was basically about the issue of rights denials and the Supreme Court and the court's role with regard to rights. But I'm going to talk about that and something else. And perhaps this is over dramatic, but I think the Supreme Court of the United States is having an institutional crisis. And so I want to talk about that crisis aspect as well. And it's certainly related to, obviously, things that the court has done in the area of rights, but I think it is also slightly different. Let me just mention a couple pieces of evidence maybe that suggest something's going on. Apparently last week, the US Supreme Court had the lowest approval rating in its history. Now, the Supreme Court has always had the highest approval rating in its history in the sense of compared to the other branches. It's always done much better than the presidency and Congress, or almost always. Its public approval rating is 40%. Apparently, that's a low according to this particular reputable poll. So that's a sign something's going on with regard to the people and our attitude towards the court. And as someone who teaches in the area, of course, that concerns me because I think the court can do incredible things, but it can also do things that aren't so incredible. So one of the things it has done recently that I would say is partly to blame for this decline in poll ratings and is not so incredible is there have been some major reversals regarding individual rights. And although some of them are not unexpected, I think this has caused the court in the public eye to be perceived as what one might call political as opposed to legal. Not that it's not legal, its decisions are written in legalese, very sophisticated legalese, but certainly there's some belief that maybe there are some political agendas that the justices have, and we can talk about that. And that's certainly, I'm not the first person to say that. But I think the crisis part comes in not just with that, but we have some ethics issues with the US Supreme Court that are really weird and troubling. And so I want to talk a little bit about that as well, and I want to make sure to get it all in time so you can ask me tons of questions if you're interested. So let's start with some of the cases in which some rights that people had have been taken away. And that's kind of unusual. We think of our court, at least I always have, as a court that at least slowly advances forward in a way and progresses forward with regard to rights. And we have a court right now, I think, with a clear group of 6 justices who have a different agenda with regard to these rights. And, from the perspective of, I think, many of the American public are moving backwards. I believe the statistics were something like 61% of Iowans don't want to see Roe versus Wade overturned. And I think those statistics are comparable to national statistics. So you have an issue that is, of course, an issue of great controversy and a difficult question. I don't want to deny that. But nonetheless, it's still a little bit rare for the court to, with that kind of a sort of political percentage, even though they are not supposed to be political, to really go so far in the other direction. And what do I mean by go so far? They reversed Roe versus Wade. Let me say that again. It's amazing. They reversed Roe versus Wade. It's a almost 50-year-old decision. It had been upheld at least a half dozen times already. It, in 1992, was reaffirmed in a major decision in which 3, what you might call Republican justices, Souter, Kennedy, and O'Connor, joined together to write a plurality saying, it's not our job to overturn decisions we make. There's a doctrine you've probably heard of called precedent. It's our job to follow precedent. And they actually have a line in the opinion, it's fascinating, where they say, we may not have agreed with the original decision, but as justices, we're bound to sort of follow it if society has built some reliance on that. So why did this happen? Well, I mean, the short and simple answer is President Trump got 3 appointments. He got 3 appointments. And the part that outrages me is not that he got 3 appointments, but that he got the 3 appointments in part because the Republican Party rejected the nomination of Merrick Garland. And we just cannot forget the significance of that. President Obama nominates Merrick Garland. There's plenty of time left in that year. All of a sudden, a doctrine I've never heard of that you can't confirm or discuss Who justices are going to be confirmed in an election year is brought to the table. I think it's nothing more than a pretext, if I can be blunt. And you should feel free to disagree with me. I think disagreement's good, but to me, it was a pretext to not allow that other justice to be there and to try to allow President Trump the opportunity, if necessary, to get an extra slot. So, what the court did, what these justices did was, as I said, reject precedent. And that's unusual in a case of that amount of significance. What's also unusual, and I think this is something people ignore, and this is the argument the other side makes. The other side says it's okay to overturn a case that was wrong. In that case, Roe versus Wade was wrong at the start. This is their argument. But I want to take that argument on its face, and I want to say, even if you're right, that it's okay to overturn a case that's wrong, what the doctrine of precedent says is you slowly build up to changing the law. So if you think about Brown versus the Board of Education, which occurred in 1954, that overturned the Plessy case in the 1890s. During that roughly 60-year period, case after case slowly cut into Plessy versus Ferguson. So by the time we got to Brown, although it was still a stunning decision, it wasn't that big of a surprise because we had the segregation already removed in graduate schools and other places. What's different with Dobbs is there was no incremental set of steps that suggested they would do that. The last major Supreme Court case on abortion before Dobbs was about 6 years before and had been a very pro-choice case. So what I say to the people who defend the idea that you can overturn something that's wrong and still be consistent with stare decisis is I say, well, precedent, that's the Latin term. We have to learn Latin terms in law school, so we sound like we're educated. The idea that you can overturn something is certainly true, but to overturn something of that magnitude without having a buildup, and I'm not saying I wanted it overturned, of course, either. I support Roe versus Wade and Casey, but that there wouldn't be a series of cases. Some of you may know this. Chief Justice Roberts in Dobbs did not agree with removing Roe versus Wade completely. He said, well, we're talking about a Mississippi law that sets a 15-week ban on abortions. And he said a 15-week ban is a reasonable place to go if we're at a point where viability is the line where women can choose. That is a much more traditional way of beginning the process of saying, well, something was wrong and we're going to do it gradually. There's nothing gradual in Justice Alito's opinion. And it's especially entertaining, not in the best sense of the word, but it's especially entertaining to read his confirmation hearing questions and answers with regard to Roe versus Wade when he was asked about it and affirmed it was a very important precedent. And he has a line, though, in the Dobbs case, the abortion case, which says Roe versus Wade was wrong from the start. It's politics, I get it, but it's a troubling combination. The other thing that happened in Dobbs that's bizarre is there was that leak of the case. The opinion was leaked, and it was pretty much the full opinion that was leaked several months earlier. That had never happened that I know of in the court's history. Lots of rumors about that. I was talking to a colleague the other day. I'm not going to go into the rumor part. I have my own perspective. If you want me to share it, I can do that under the conspiracy part of the discussion today. But how did he come up with this decision besides thinking the case was wrong? Well, he thought it was wrong also, and this is very important, because he uses a method of interpreting the Constitution called originalism. And originalism is an approach to the Constitution that says when you try to interpret what the words mean, you look back in time historically to when the 14th Amendment or some other amendment was enacted, and you say, well, what did it mean to the public at that time? The problem with that is the 14th Amendment, just to take an example, which is the foundation of Roe versus Wade, was passed at a time where women had no rights. So Intuitively, I don't understand this. I really don't understand this. If we were to go backwards, we would have no Brown versus Board of Education. That never would have happened. So one of the things that's going on is these cases that are, I think, really bad, and I think make some people think the court has an agenda. The second area that's unbelievably significant is affirmative action. You may know that the US Supreme Court has now reversed a view from a 1978 case that allowed affirmative action in college and university and law school admissions. The court back then said that the reason affirmative action, which allows for preferences to be allowed on the basis of someone's race in part, but although you had other areas where you could have preferences, so if you wanted to bring in a good football player or an amazing violinist, the whole idea was diversity. The whole idea of affirmative action, according to the court back then, was it is within a university's authority as an educational institution to decide that diversity is beneficial educationally, because we live in a world where people are going to interact with people of other cultures, and we need to have conversations. And the place where people are probably going to have conversations of a like that they may not have on many other occasions is at the college setting, where you can really deal with some of these issues. So the overturning of the particular affirmative action cases are highly significant because they basically also say that diversity, the idea of promoting diversity in the university setting, is not legitimate. Here's the big question mark. What about other settings? And we don't know the answer. But the way they go after diversity as something that is a unacceptable justification for a university to make its admissions decisions, because they believe in what they call colorblindness. I'm not sure what country they live in, but I see color. I think people who are racial minorities see color and experience all sorts of things that are just unbelievable, in part because of racial discrimination on the basis of their color, and other groups as well. So this is a big issue, as I said, not just because of what it does to universities, and our university and other universities now have to think about, how do we try to accomplish some of those same goals? And the court did say that students could write essays that discussed the things they had overcome, maybe racial bias or something, and those would be acceptable. But it's still not at all the same thing as affirmative action. So that's a second case that overturned a precedent that goes back to 1978. So again, I don't know what it is about 50 years, but Roe is 73, Baki's 78, almost 50 years. So both of these cases are thrown out. The big issue, as I said, though, in this area is, what about diversity in other realms? Diversity in hiring, diversity, in various groups. Is that not permissible if the groups have connections to the state? Diversity training. Diversity training is an issue sponsored by the state. We don't know the answer. I mean, my interpretation of the case, candidly, is a quite narrow one, which is they said it can't be used for college and university admissions. Therefore, they haven't spoken on the other potential uses, and they haven't said the other uses are illegal. So I think they're okay. But if I were a university counsel, I would not be unaware of the possibility that if I make too much about our great diversity program, we might become a target for a group. There is a group that exists bringing these lawsuits. It also affects scholarships. So it's not a good decision in my particular view. Another case involved a web designer, a woman who designed websites, who refused to essentially put up a website that would have had basically information about an endorsement of a same-sex marriage. And we've obviously in Iowa seen this issue and other places. And she said she had a religious objection to the idea of putting this up. So what you see, and this is going to be an issue for many years, is an unfortunate conflict between people who have religious views about LGBTQ people, and then those people who should be able to live their lives, who I candidly believe should be able to marry, and who I think any entity that holds itself out to the public as a public business should not be able to engage in that kind of discrimination. The court ruled in favor of the web designer, or to put it bluntly, religion won over gay rights. And that's the second time in a way that's happened. There was another case some of you may have heard of about a wedding cake that occurred a few years ago, although it kind of had a technicality that you could say, well, it wasn't so clear. It's a little clearer now. So, this is trouble. But I'll tell you what's the most trouble from the perspective of a lawyer. It's not clear there was any lawsuit to begin with. If you followed the information about this case, it's not clear there was actually someone who had asked this woman to do this. It turned out there was some rumors about a person his name was Stewart, who had asked about this, but even the rumors apparently had to do with things that happened after the lawsuit was filed. Now, there is a doctrine with regard to free speech law that if your speech is threatened in advance and you know it might be cut off, so that's what the woman is arguing, even though it's based on her religion, that it's her speech, that she can seek protection before it actually gets cut off. And this is called pre-enforcement review. The court found that the reason this lawsuit could go forward was it was a form of pre-enforcement review. Those of us who are cynics about that say there was no plaintiff. And the term for that is there's no standing. There was no one who had been injured yet. This woman hadn't done this yet. The Kate case, actually, there had been an actual interaction, et cetera. The part of this that then gets more complicated is it just seems to be that when the case involves a conservative issue brought by a plaintiff, they find standing. And there's a very interesting case regarding journalists during the War on Terror being deterred from being able to have contact with potential sources, in which the court ruled they have no standing. They're not injured. So it seems like, there's standing when they want there to be, and there's standing when they're not. And those are the kinds of procedural things that a lawyer like me gets troubled by, in particular, not just the sort of more well-known, famous substantive issue. Last but not least is President Biden's tuition forgiveness program, which was thrown out. It was thrown out as unconstitutional. Generally, the president's ability to use executive directives to do things, especially when they are consistent with some laws that were on the books, and there were some law on the books that had some discretion, it seems, for the executive branch, they get a lot of deference. But the court said the Biden program, which was a big program, $400 billion, up to $20,000 per person, there is no doubt there was a big program. And I have to give a little bit of props to Chief Justice Roberts, who in rejecting the program said, we don't think that his program is just a modification of these earlier laws. That's as if you were saying the French Revolution modified French nobility. So I got to give him a little credit for being clever, but wrong. Clever, but wrong. And obviously, President Biden has proposed some other and new ways of trying to help people with tuition. Talk about a huge issue for our country. We need our kids and our students to get educations and go as far as they can with that. We need an educated populace to deal with the political situation we have, people who can talk to each other. So, this is a troubling situation, a troubling decision. And as I said, there may be, and I think it's fair to say, there's sort of the appearance in some of these cases of a agenda, just given their consistency. Now, I want to be fair to the court. They did decide a couple cases liberally last term. The most interesting one was they they ruled that Alabama was using racial gerrymandering with regard to the vote. But if any of you have followed the story, Alabama went back to sort of redistrict and then still gerrymandered. And the New York Times had a great story. I mean, this is not nice. I hope I'm not offending anyone from Alabama, but so it was on the cover of the New York Times, so I can talk about it. Alabama again, this is roughly the title. Alabama again finds itself not following the Supreme Court decision. So they've been told they have to redraw this district. It denied at least an opportunity for probably one more black congressperson in the state. But the decision of the Supreme Court was good, and they seem to be all over Alabama about this. There was a very weird theory that electors for who becomes president, that state legislatures could choose them, not the people. This was a marginal theory that no one took seriously 15 years ago that was now right in front of the Supreme Court as a big deal. The Supreme Court did not allow that, so that's good. And they ruled in favor of, I think this is good, the Native American Child Welfare Act, which created some preferences in those areas. How did that happen? Justices Kavanaugh, Chief Justice Roberts, and Justice Barrett have a little bit of flexibility and seem to, on occasion, vote with, quote, the liberal group. It's fair to say that doesn't happen with Justice Alito. It's fair to say that doesn't happen with Justice Thomas. And Justice Gorsuch is interesting because on Native American issues, he's quite good. He's from the Southwest. But almost all other issues, he's not so good. I noticed I'm running out of time, so let me get to the ethics issues real quick. You guys have read the newspapers, right? Justice Thomas has had a good time. Thomas came to my law school and talked about, we got to spend time together, and he talked not just to me, but to others. Boy, on my vacations, we just take this RV and we go to the Walmart parking lots at night and we get to meet people, and the people don't know me, and it's really, really nice. And I'm just an ordinary guy. Well, you are an ordinary guy, but it turns out your RV was paid for, which I didn't know. That was an interesting tidbit. It turns out you had numerous visits to this billionaire's either residences or resorts that you didn't disclose. You're a member of something called the Horatio Alger Society, which I just can't believe the name still exists, but because I think he's doing okay in terms of rising up the social skills. So this image of Mr. Ordinary he has cultivated, it's just not true. His wife, she's something. She was found to be literally calling the White House and Mark Meadows and telling them, do what you need to do to overturn this election. Justice Alito had some fishing trips involving billionaires that were helped that weren't disclosed. You all probably know about the Federalist Society. Well, new work by ProPublica has disclosed that they are not simply a conservative organization that tries to facilitate conservative thought, but that their leader, who is no longer their leader technically, but Leonard Leo, had the support of billionaires and certainly had the voice of Donald Trump with regard to selection of judges. There's just no ethics code for the US Supreme Court. That's the problem. The US Supreme Court, unlike every other federal court and every federal judge, they're not subject to an ethics code. They are their own ethics code. To their credit, Thomas and Alito have, well, more Thomas than Alito. Justice Thomas has admitted mistakes and he said he's going to correct things. Justice Alito is also going to correct some of this paperwork, although he doesn't like to admit he made mistakes. He's pretty upset at those people who would dare to suggest that he had not acted in an above board fashion. And the last thing I'll mention that is really perhaps the ticking time bomb that doesn't get as much attention is we are seeing now a period of time, and this is partly revealed by the tuition case involving Biden and the education department. The people in the US Supreme Court do not like federal agencies. These agencies came out of the New Deal. They don't like the New Deal. If you've seen President Trump recently, he made a statement apparently, or some of his acolytes have basically said, when we take power again, we're going to remove the independence of the Department of Justice, because the problem with these agencies is they are somewhat independent. And apparently there's going to be a systematic effort to limit their independence, to make them more beholden to the president. And I can't use any other word but to say that's somewhat of an autocratic thing to do, not a democratic. Not a democratic thing to do. So what you have is the case law going in a direction that seems to be following a conservative agenda with very few exceptions. And then you have these ethical issues which seem obvious, and there are some solutions. You could have term limits for the justices, for example. You could put some sort of a code together. There's an informal kind of code that exists, but for the most part, it is not the same thing as a required code. We have a confirmation process that is, I think, politically bizarre at this point. So there are things that can be done. But I think right now that 40% approval rating, going back to what I said at the start, is a sign that all of these things together, and I'm not even sure Bush versus Gore is irrelevant. Going back to Bush versus Gore, for those of us who remember, at the time people said this really hasn't changed people's opinion of the court too much. But if you put this whole thing together over a longer period of time, you start to wonder a little bit. Because I was trained that the Supreme Court makes its decisions on the basis of what constitutional law means and says, and what precedent says, et cetera. And I can't help, and certainly my students are not naive. And you just can't help but think there's a role for politics here that is somewhat inappropriate. So thanks for listening. I'm glad to take questions.
Thank you so much, Mark. If you have questions, it is our habit that I will bring the microphone to you. So I see lots of hands up. I'm going to start here. And I don't see any over here yet. Okay. So I'm going to start here and make my way around. Just catch my eye, and I will try and do so in order, although this is not going to be in order. So.
Thank you very much, Mark.
How are you?
Question, I think it's the 14th Amendment. Do you think there's much likelihood that we're going to ban Trump from being able to run for president?
We had our Constitution Day event yesterday, and we had a person come out who's very much an expert on that kind of thing, and a bunch of us were talking about it. Just so everyone knows, there's a provision, Section 3 of the 14th Amendment, that basically says if you took an oath but then participated in an insurrection, I mean, just think about that. This kind of makes sense, right? You took an oath and you participated in an insurrection, that you're not generally then allowed to be seated in office. The question is, what's going to happen? Several lawsuits have been filed, but secretaries of state who've been interviewed said, I'm not going to keep anyone off the ballot who has received the necessary votes, whether it be a primary or other mechanism. I think that's where I stand. In other words, I think it would be great if that was something that was enforceable, but I also think there would be a huge backlash. You think you see a backlash now. I think the backlash there would be immense. I mean, literally keeping him off the ballot. What have we accused President Trump of? And the Republican Party, some people have accused them of trying to keep people from voting. So we also run into a little bit of the hypocrisy issue. As a legal matter, I was asked recently about it. It's very complicated because it depends on what the word insurrection means, and what the word insurrection meant when it was put into the 14th Amendment in the 1800s. It's not quite the same thing that it means today. And so that adds to some ambiguity. And if you remove someone from potentially being voted for president based on ambiguity. So while I think it's a very strong argument that deserves a lot of attention, and maybe some of these courts will rule on this, I just can't see secretaries of state throughout the country systematically disenfranchising what amounts to a candidate and then thousands of people who might want to vote. Am I possibly wrong on this? Absolutely. I mean, I have a long history, as my students will tell you, of predicting things that are not true, but that's my, but my prediction is that I don't think that will take place. But I could be wrong, and maybe it takes place in some states and not others, right? Because We'll see. But if it gets to the Supreme Court, they'll decide it for the whole country. So I hope that's an answer to your question.
We're over here.
Hi. The Brennan Center for Justice has started a new site that's devoted to how the state legislatures are changing laws in regard to the appointment of state Supreme Court justices. That's certainly happened here in Iowa. And what are the implications here in Iowa as well as around the nation for those changes?
Yeah, I heard about the project. I haven't really read about it or read what the project says. I think they just released their first study, which I looked at yesterday and said, oh, I don't have time to look at this, but I want to. So yeah, you have some changes in Iowa that put a little bit of an edge in favor, I think, of probably the Republican Party with regard to the Iowa Supreme Court. State Supreme Courts right now are becoming very strange places. You know, in Wisconsin, they just had an election to have a Chief Justice. They finally elected a Democrat after years of Republicans, so it's now going to be 4-3 Democrat. And immediately the Republicans have announced they want to impeach, which to me seems to be a workaround with regard to the procedures there. I'm not familiar with all the different things going on in states in this area because I focus mainly on US constitutional issues, but I'm sure there are other mechanisms in place to try to put limitations on the power of a court if that court is heavily Democratic and the legislature, for example, is heavily Republican. It's a sign of our just turmoil in this country. You know, the speaker I had yesterday actually spoke a lot about Watergate. And the thing he spoke about the most was the dignity with which Republicans acted during Watergate. And in fact, that dignity was the key to the fact that Nixon eventually resigned, that these people, you know, and I'm not saying Republicans don't act with dignity now. There are plenty of incredible Republican politicians who do incredible things. But I think that sort of idea of acting with dignity in our political system is no longer valued as much. And I think this is an area where at the state level, you can really have an effect pretty quickly if you can get enough people. It makes me think, I hate to be sort of too weird, but you know, James Madison, our founder, wrote in the Federalist Papers about the worst danger in the United States that we're creating is something called faction. And that faction is when you get a very passionate group of people together who pretty much don't listen to reason. And even if they're a minority, if their passion is strong enough, and that's one of the things actually I meant to say, one of the things that's going on right now is minority power. If you look at, you know, sort of people who are in the Senate and in the House, et cetera, and you look at the successful redistricting by Republicans, you'd see Democrats should have a lot more people, for example, in certain state legislatures, maybe in Congress, than they do. And the idea of minority rule, you know, is another example of this sort of problem that we got. So the short answer is I can't give you many details except the couple states I mentioned, but I'm sure there's much more going on.
Utah Senator Mitt Romney has a book which is about to come out, and there's been like an excerpt in which he says many interesting things about the Senate, his colleagues, other leaders. But among the things which struck me was he said apparently maybe half of the Republicans, and I don't remember now if he was referring to the electorate or to the office holders, no longer support the Constitution. And I wondered, you as an academician, someone an expert on the Constitution, what becomes of us when we don't support the Constitution?
Wow, that's a great question. So let me start by saying that I think people, and I hope I don't offend anyone too much here, but I think people who pretend that there was no election that was legitimate, that took place, that put Joe Biden in office, or who don't think that January 6th, which is one of the most tragic days in American history, were a big deal, are really ignoring basic elements of what our Constitution was meant to do, which is to have the rule of law, to have systematic elections take place, to have those elections recognized. The 25% figure I've not heard before. What I've heard is that's the outward figure maybe, or there may even be a larger outward figure in terms of there are lots of Republicans who still won't acknowledge that Biden won the election. But what I've heard, or at least seen on some interview shows, is that the correspondents say privately, if you get the Republican in a room by themselves alone, they will say something completely different. So I guess my observation would be that's incredibly troubling, and he's probably right in terms of the number, and maybe it's even higher, who are publicly saying and doing things that are contrary to our Constitution. Privately, though, I'm not so sure they really mean that, but the private part doesn't matter. I mean, this is going back to the essence of what Romney and you're sort of suggesting, right? It's the public part that matters, and if they're not publicly willing to acknowledge that, it's really disturbing. And if the figure is 25%, that's even more disturbing. And I have really good friends who were Republicans who've become independents, and that's why. You know, they are Republicans who I would say were very devoted to their party, but you know, they feel like their party has lost its way, that it's not following the Constitution, that it's following a person. You know, the sort of persona of a character who's very charismatic and all of that. But if that figure is correct, it's incredibly disturbing. So I didn't know that. Thank you for telling me.
Okay, hello. Following that, I feel like my question or my comments are rather frivolous, but I have read about scholarships not being able to be directed towards minority students. And I personally have set up a scholarship only for females and only for Latinas, because that's part of my heritage. And I don't want somebody to tell me that I can't direct this money to go to a certain group, a certain population who are trying to improve their lives and earn a profession. So do you have a comment or response to that?
So let me make a little bit of a leap, but what you said reminds me of the effort, successful apparently in Florida, to ban critical race theory and to ban discussions of slavery to the extent that it's more limited than it used to be. As an academic, there's just nothing more offensive. I mean, you know, putting aside the politics of the court and the legal part of the court, my ultimate goal as an academic is to try to figure out what's true or not and what I think is the right answer or not. I'll never get there, but I'll keep trying to close off this whole area, which has been incredibly insightful in terms of showing us that race here is not just, in my view, sort of a person by person problem, but the systemic elements of racial discrimination. Very early in my career, I had a debate that I hosted, and one debater was supposed to argue that racism is systematic in the American legal system, and the other debater was supposed to argue it wasn't. And I thought the one who would have to argue it was systematic would have a hard time. I think the one who was systematic and argued that wiped the floor. Wiped the floor. If you just go through so many areas, prisons, education, rent for housing, jobs, you know, and just sort of see how much discrimination, and you know this better than I do probably. It's terrible. So you've really hit on a sort of nerve for me. The idea of not letting our students hear about critical race theory, they don't have to agree with it. And they can learn whatever arguments they want to be against it, but to say they can't be exposed to it because, I don't know, what is that, cooties? To use an old term from my elementary school days, you know, I just think that's mind-boggling. And, you know, it's here in Iowa, right? I mean, it's not just Florida, it's Iowa, you know, and, you know, it's resulting in book banning and other things here that are really scary. When I hear book banning, that just inherently makes me think of something that's somewhat authoritarian.
You mentioned, said something about the way we select our Supreme Court justices as being bizarre, which, yes, I agree. How would you go about, what would you suggest that we do instead? How are we going to
Well,
get these people out of
I
the
think the first thing actually starts at the other side. We have life tenure in our Supreme Court, in our Constitution. We could, without amending the Constitution, actually, and there's a very clever work method that people have come up with, scholars have come up with, limit the terms of Supreme Court justices. If you limit their terms to 18 years, all of a sudden the confirmation process, that's the figure people have come up with because it coordinates with 3 US Senate terms and anyway, it's just a term, it's just the number that people have come up with. What you end up with then is, first of all, it reduces the importance of the confirmation process. So it's not such a monumental life or death struggle because you know you're going to have a rotation of the justices occur. So if you did that, I think it would automatically have an effect. The question then of the hearings themselves, I have to say I'm a little bit divided in terms of, I think there's 2 possible solutions and maybe neither one is perfect. If I think there's 2, I can't figure out for sure which one is best. I don't like the sort of what I call kabuki theater type thing we have now where, you know, people get asked questions just as Alito gets asked about Roe versus Wade and says it's an important precedent. Come on. But, you know, so I don't like that game that we're playing now because there's just an inherent dishonesty to the way you have to play the game to get on the court. Justice Sotomayor had to say, I will never use foreign law in my decisions to get on the court because of something else she had said before she was on the court. If she hadn't said that, she was not going to get on the court. So that dishonesty bothers me. The alternative would be to say, these justices have to answer the questions, no matter how blunt they are. That also is complicated, though, because I don't want justices telling me before they're on the court how they're going to rule. So you need to find some middle ground. And I do think that's quite difficult. You know, maybe if there's a way to take the politicians out of it and let the bureaucrats run the show with the politicians just being the mouthpiece for questions. You know, we've seen agencies and hearings in Congress where even though Congress was having the hearing, it was really the lawyers behind the scenes who were kind of running the show. Maybe they would be slightly less political. But candidly, I don't know the answer other than if it was less vital to the nation's interest, if the person wasn't going to potentially be in office for 40 years, it would automatically become less of a matter of life or death, and it would automatically become, therefore, more tolerable, I think.
Question about what may be an upcoming Supreme Court decision, the pros and the cons from a constitutional point on DACA.
Which DACA is, I guess, I mean, there's so many different, aren't there sort of a bunch of amendments that have been added from the original one, or am I wrong on that? Please tell me I'm wrong on that.
I don't know.
Yeah, I don't know DACA well enough to give you an answer to that, other than it is fairly clear that the court is not friendly towards immigrants. And I think that's a sign that to the extent, you know, if I understand DACA correctly, it's helped young people who are here illegally, but nonetheless, you know, are here maybe even not by their own fault, to have the opportunity to still have an education and to go forward with their lives. To me, that sounds like a great public policy. But if it's a public policy that's something that comes out of the executive branch without some good legislative foundation, and if you ever want to see something that's weird and has really strange aspects of a legislative foundation, I'm not telling you to do this literally, but read our immigration law. We have an Immigration and Nationality Act. I don't know, DACA must have some connection to that. The Immigration and Nationality Act makes no sense. It makes no sense. DACA, to me, makes sense, but constitutionally, it seems like a court that would not be naturally friendly to it, but I don't know enough.
But for a constitutional reason or just because they're anti-immigration?
I don't know enough about DACA. I mean, it's a federal program, from what I understand. And the way cases involving immigrants work is, to the extent the program is federal, the court is more respectful of the federal government doing things to help immigrants. And if it's a state, the court says, well, the states don't have anything to do with our national immigration policy. The fact that it's federal is helpful. I think the fact that it does some very good things and involves some people who are incredible people, I think that's a good thing. I'm not sure the court cares about this. I think the court would want to drill into, you know, where does DACA come from? What are its foundations, et cetera? But I don't have a definitive answer other than it would make me nervous. I just read before I came here yesterday a whole list of the cases in front of the court because I wanted to be able to answer questions like this. I didn't see a DACA case, but there is a big case involving the Consumer Finance Protection Bureau, and its constitutionality will be up next term, and I don't think that's a good sign. But I didn't see a DACA case. It's in process. Right. Oh, I get it. Yeah, I understand.
We're going to go over here.
Thank you for a great talk, by the way. And could you talk a little bit about our constitutional right to freedom of speech? Because the way it appears to be at this point, we're using that right to basically agree with and accept lots of uncivil behavior, and we're using more as a behavioral thing rather than actually freedom of speech. And I'm old enough to remember when actually, like, for example, what we would call a hate speech was something that we talked about and believed in. And I don't think I've heard that term in I can't remember how many years. So I think freedom of speech is really causing problems to you. And what's your thought on it?
Well, I think coming from a college campus, a university campus, some might argue we are the place where the debate about hate speech is actually still occurring. I think you've had a number of incidents in which right-wing speakers have been shut down by left-wing student protesters. You've had some incidents that have gone the other way as well. You know, there's the famous incident out of Stanford. I don't know if you followed the incident at Stanford where they had this conservative judge who by all accounts was fairly unpleasant to start with. And then the students got riled up, and the associate dean or one of the deans for students got involved, and she's now been fired basically because she sort of shut the speaker down. I think our free speech laws are going to have two things going on right now. You're going to have conservatives who are increasingly, and this court especially, are almost uniformly pro-free speech and are not going to want to see restrictions, even if it's racist hate speech, you know, absent some incitement, absent some violence likely to take place. And I think what we're seeing now on what I would call, I guess, the progressive side is a lot more questioning about the value of speech. So I used to be involved with the ACLU here. The ACLU today is not the ACLU that defended the Nazis at Skokie. I'm not saying they wouldn't defend the Nazis at Skokie today, but it is a much more diverse ACLU. It does not see speech as necessarily its only function. So I think you're going to see this fight going on between the left saying, and I'm not labeling you in any way, I apologize, but people on the progressive side much more concerned that free speech is lousy and bad and does really nasty things and harms people and can cause all sorts of problems. And people on the right saying, there you go on the left, you're the censorship people, not us. And I think we're going to see that debate. And I think it's definitely occurring on college campuses, and it goes with the diversity issue. You know, the diversity issue is partly about what viewpoints do you allow. And my basic idea is you should probably allow most of them, but there probably should be some limits in terms of harm to people's psyche, their lives. These are kids still. So I hope that's a partial answer to you. What do you think?
Well, it's a struggle for me. We deal with this a lot, you know.
Oh, right.
And, you know, I think about freedom of speech like
We got people online that can't hear
Oh,
you.
sorry. So if a teacher can stand in the front of a room and say, look at her classroom and say, okay, all the little in children need to do this, that, or that. Okay, is that freedom of speech? And, you know, or is that hate speech? Or can you control that? By the same token, if she wants to talk about diversity, then she should be allowed to talk about it. So I'm confused about it, you know, and I'm just trying to figure out where the law stands and where you stand and where
Sure.
we as a, I think we as a country have to figure out how we stand on this. If
So
I'm
on
correct.
that specific issue, I think the law is quite clear, not quite clear, that's. I think the law is that it's certainly within the power of a school or a university to prevent a professor from using the N-word in class and to discipline that professor for using that word, with the one caveat being great works of literature. What if it appears in a great work of literature? Although even there, you can still avoid sort of using the term over and over again. In the public square, I think the government cannot stop people from doing and using that word unless it's insightful, unless it's inciting violence. So the context, what's called the forum, where it occurs differs. But in the school context, I just don't think there's any doubt someone could be disciplined for that, assuming most schools do, like Drake does, which has kind of a, you know, an aspirational but also enforceable set of provisions about, you know, some level of acceptability. I don't think they list specific words, but you know, I think that one in the school context, the idea of disciplining the professor or the teacher would be basically something that the court would not view as a free speech violation. But if it's outside in the public, people can leave, they're free to go, unlike a classroom, and they're not inciting violence. And there's a case called Brandenburg where the KKK had this pathetic rally where no one showed up, but they said all these ugly things. The Supreme Court said, look, there was no evidence anything was going to happen. You guys were kind of pathetic. Basically, you guys are kind of a pathetic group right now in terms of what you're doing here, but there's no evidence of incitement. So we can't convict this person of violating anything because it is their free speech. So I think one answer to your question is, which forum is it?
Mark, this is the last question.
Okay.
Hello.
Hey.
I have two questions. Sorry. My first one is, why would Justice Thomas assume that the same reasoning that he gave to Dobbs would not affect interracial marriages? Also, what about adding more Supreme Court justices to the court?
So the second one I'll take first. Yes, one potential solution that has been proposed mainly by people on the progressive side is, you know, the court should in some way be balanced. And the way you balance the court is set up some mechanism where you can add some justices so that, you know, you don't have that 6-3 split. I think that's a very plausible, I mean, good idea in the abstract. I don't necessarily politically see it occurring, but in the abstract, it might help, although there would be all sorts of details you'd have to work out. Because if you just added 3 more Republicans, you know, so you, I mean, how are you going to get the Republican Party to join in and say, "Hey, I have 3 more Democrats"? So you'd really have to restructure the court in a way. And I apologize. The first question was about Thomas and
Why his decision.
Interracial marriage.
Arguments would not affect interracial marriages.
well, I think he has real funny problems in terms of some of his. I'm sorry if I'm being too honest. He has some consistency problems. So in Dobbs, he wrote that we should get rid of some other fundamental rights potentially. And when you think of fundamental rights, you think of interracial marriage perhaps as one of them. If I recall correctly, though, in that concurrence in Dobbs, the fundamental rights he cited were not racial. He omitted them. What's the easy answer to your question? I'm not going to talk about it. But yes, there is inconsistency there. And if he wants to get rid of these other fundamental rights, you know, marriage isn't in the Constitution. There is an originalism argument for heterosexual marriage that he might be able to fall back on, but not interracial heterosexual marriage. So you're absolutely right. I mean, there's an old saying, I apologize if you've heard this before, consistency is the hobgoblin of little minds. Well, I'm all in favor of some hobgoblin. Let's be consistent. So,
Help me to thank Mark Kende, please. Thank you so much for being here and for spending time with us and sharing your expertise on this subject, and would encourage everyone to continue the conversation of the challenges to our Constitution. Next month, so Crossroads is every month on the third Friday of the month. So if you're new to us and are not part of our email list, we make sure that you have that information and what will be coming up. But I will tell you that next month we have Sue Woody, who is the head of the Des Moines Public Library, and she's going to come and talk with us about books and banning books and a lot of other challenges that they have in the public library system. So come back and join us again, make your reservation online. Have a great weekend.